scheduling a closed meeting to discuss different things isn't...
No. You have a board, and that board has an employee. Is the CEO of the hospital an employee of the board?
Employee of the district.
Employee of the district. Yeah. So works for the district. The boss of that hospital CEO is the board, like a superintendent's boss is the school board.
Right.
So library director is the employee of the library board. So in those situations when it comes time to do the performance evaluation of that employee, does that employee have an expectation of privacy?
Yes.
Yes. The courts have said yes. There's only a handful of things that the court says are private. Go ahead with your question, I'll give you a list.
Unless she waives the right.
Right, which we'll get to. Get ahead of me here. Get ahead of me. All right. There's just a handful of things that would be considered private. Right? One would be employment records, personnel records, military records, IQ tests, family issues. Like, I've got family issues, none of your business. My family issues, none of your business. Drug and alcohol issues.
Background checks?
Did I say medical? Medical issue, or medical records are on there. So it's just a handful of things that would be considered private. So,
What about, at the library, we do background checks
yeah.
through the state of all employees.
And I would probably consider those background checks as being a private
Private.
document.
Oh,
Ours are.
And my point is that you, as a public agency, do not have an expectation of privacy. The city, the county, the board does not have an expectation of privacy. However, you may be in possession of private information, right? The employee records, you may have. So I'll do a scenario here in a minute. Let's just read what the law says. Look at 23203, subsection 3. The presiding officer of any meeting, so the important person here is the presiding officer. It's the board chair, it's the chair of the commission, it's the mayor of the city. The presiding officer of any meeting may close the meeting during the time the discussion, underline that one, the discussion relates to a matter of individual privacy. And that if and only if the presiding officer determines the demand of individual privacy clearly exceeds the merits of public disclosure. The right of individual privacy may be waived by the individual about whom the discussion pertains, and in that event the meeting must be open. So what all that means is that you can close a meeting when you're discussing, right, underline that word, a matter of someone's individual privacy. How I would operationalize that. So the county commission says, look, we need to discuss this employment issue. You have an employee here that here's a scenario. You've got an HR policy, hopefully. Don't tell me if you don't, but we'll assume you do. Okay, you have an HR policy. And as an employee, I can go to my supervisor and say, I would like to take leave without pay for 6 weeks because my mother's fallen ill with cancer and I need to go care for her, but I only have 2 weeks of vacation time. And my supervisor declines my request. I can appeal that request by going to the county commission. See, I've set a scenario, because typically you shouldn't be dealing with these issues. It should be dealt with anyway. Okay, now I can appeal to the county commission. Now the county commission has to hear that. Is it the public's business why I want to take leave without?
No.
Okay, it's not any of their business. So I requested to have the appeal to the commission. The commission then can come back to me, the chair. The commission should contact me as the employee saying, look, we're going to have a next meeting. We're going to discuss your request and your appeal. All of our meetings are open to the public. However, you may consider this to be an issue of privacy. Would you like to exercise your right to privacy and request the meeting be closed? And if the individual says, yes, I would, you say, I concur, we're going to have that as a closed executive session. Now, if the employee says, no, I don't care who knows, I want that meeting open, then what did it say? The meeting must be open. Right? You can't exercise someone else's right to privacy. And on the flip side, well, which also means you shouldn't be holding meetings, executive sessions, talking about an employee without that employee being noticed. We're going to talk about you. You have a right to participate in that. right? So it should be, what I always hate is getting a call from some poor old employee, either the city or the county, saying, I just learned that last night they had an executive session that talked about me, and I had no idea. Don't I have a right to know? And I would say, well, I think so, because you were never given the right to exercise your right or to waive your right. You should have that. The other thing I keep talking about, the discussion pertains to an individual right to privacy. It doesn't say action. Why don't we? So my position is we don't take action in executive sessions. Why not? What must happen before you take final action? Public comment. That's why I think the legislature deliberately said discussion pertains to some of the issues of privacy. Now, you have this discussion with this employee, and then you open the meeting and say, okay, we will take public comment on the appeal from Betty Sue for her leave request. Is there any public comment? Take it? Great. I move that we deny it, or I move that we grant it. Either way, but you've allowed public comment on it. They don't need to hear what took place during that executive session. That's private. But the public can weigh in on it. They have a right to make comment prior to final action. Most of the time, they don't have, I don't have a dog in this fight, whatever. Or they might say, yeah, I've got something to say. Give it to them.
Going back to the agenda,
Yeah.
being specific, can you just put on the agenda personal matter, and that's it?
I would follow legal counsel. My recommendation, I would prefer to see executive session to discuss employees, personnel appeal, or whatever it might be. So that's not private. Why? It's the substance of what's being discussed. You're not going to say that she's, wants to request because her mother's got cancer. But we're going to have this conversation. I'd rather have something there so the public knows why, because otherwise they're going to ask all these questions. What's going on? Well, we're having a discussion around personnel. But you can determine, right? And I would go case by case to determine what should be there, what level of notice should there be. School districts are a whole other thing, because now you're dealing with youth, and there's a whole different level of standard for privacy there. But usually what we're doing. Now here's the other thing I'll just say, because there could be a political move for a city manager or school superintendent. Chair of the school board says, we're going to do your performance evaluation. You want the meeting closed or open? He says, I want it open. He said, well, I don't want it open. It could be a political move on their part. We had a city manager who got crosswise with his city council over the tone of his emails. They didn't like his tone. He's like, oh, for heaven's sakes. I'm trying to get stuff done. You don't like my tone. So they wanted to have a meeting to discuss his email tone. And so he said, great, let's do it. I waive my right to privacy. Well, no, we want that private. He said, nope, I want it open to the public. Well, we don't want to talk about it in front of the public. I know. So they had that part of the meeting comes up, and it says, discussion about the performance of the city manager. And to a T, they all sat with their arms folded, their little lips out. We're not saying a word. You're doing just fine. Great, let's move on. Right? So because it's so petty. And he says, I'm not going to let you roll me over the coals over this petty issue. If you got a problem with my emails, let's talk about it here and now. But you want to close the meeting so you can be nasty to me. I don't need to take that from you. So he made a political judgment. Superintendents do this all the time. They get a little cross-eyed with their school board, and they want to have a meeting and rake them over the coals. They say, fine, let's have this meeting open, and I'm going to pack the gym with teachers, parents, students. We're going to pack the house. They love me. And I want you to say what you have to say in front of all these people. I don't think you've got the juice to say it. And sometimes they're right. We've had some situations they'll just...
But that person has to be on the agenda, right?
Yeah, it's on the agenda.
Say personal matter. Just says personal matter, and that's it?
Well,
But don't you have to say something?
It's about, to me, when it's about discipline, you don't want, it could be positive or negative there. I mean, there could be no discipline.
And we put personnel.
Personnel matter.
And
Yep.
we don't put, we're not, our HR guy is going to say, no, there's no discussion about a disciplinary matter.
Yeah.
And that's not fair to the employee.
Right, so you got to just, so it's case by case on what level of notice you want to put on it.
I mean, I'm asking, is it fair to the employee, but disciplinary matter on the agenda?
You could just say discussion about it, county employee, or it could be the discussion about performance of so-and-so.
Personnel
Because we don't know if it's good or bad.
matter. Right, and what we do
What's
is
your
we
name?
put disciplinary matter.
Barbara. Yeah, it could be to discuss personnel matter by Barbara. And so
Right.
what that is, we don't know. It could be discipline or a personnel matter relating to Barbara. Right? It could be discipline, it could be that you're appealing something, it could be, so the public doesn't know, but we know who, and it's a personnel matter. Now, they come in, you say, hey, I want to see the meeting, I want to see Barbara, I want to see Barbara's personnel file. Right? So, what I mentioned earlier, we are stewards of private information. What I would say, when I get that request, say, okay, that personnel file belongs to Barbara. Barbara needs to decide whether she wants to release that or not. I can't exercise that right for her, so we will ask Barbara if she wants that released or not. And then you get a chance to say, yeah, release it, or no, it's none of our business, right? I'm giving her that chance to say that. City of Billings got screwed over with the press on this. City manager and the police chief got in a big piston match over something. Can I see that here? It's not offending the librarian, is it? They got cross-threaded, right? So they're upset.
I taught middle school.
Oh my goodness, well then, I can really let it go.
She could probably teach us.
So this police chief and the manager got in this altercation, and the manager wrote up a disciplinary action on the police chief. The press, of course, the Billings Gazette comes to the city hall and asks for, I want to see that disciplinary write-up. And they said, no, that's private information, right? Then the press went to the police chief and said, we'd like to see it. He said, great, here it is, right? I released that information. Made the city look bad, it made them look like they were hiding something. Rather than saying, it's not our information to disclose. We warehouse it, but it's not our information to disclose. Talk to the police chief. If he signs our little form releasing that private information, we will release it. It's not our call. That's what the city of Billings does now, not our call.
I think also in some of the case law, they said like the city clerk doesn't have an expectation of privacy. So if you're a supervisory elected official, you don't have an expectation of privacy.
Elected officials have little expectation of privacy. Think of the janitor. You have a janitor here? Or you just all clean up your own mess?
No, we do.
Okay. The janitor has a higher expectation of privacy as a public employee than a sheriff's deputy. Why?
Because he's in each room and sees what
She sees where all the done rises.
And he's a deputy and elected official.
Well, a deputy sheriff, right, we're giving them a gun, a badge, and the ability to use judgment to violate someone's constitutional right, to detain them, right, to arrest them. So they have a higher public trust than the janitor that sweeps the floors. They have a higher expectation, right? School teachers, we're giving them our precious commodity, our children, for 8 hours a day, right? Well, they're not that precious for some of them. There's that break there when they're like preteens, they're not worth anything. But anyway, we've given you the responsibility, so our trust level is higher in you. Your expectation probably is lower, right? Where that scale is, that's why we haven't determined. They try to thread that needle. Remember what happened in the city Billings again, police department, about 2-3 years ago? Remember that? They had some drugs stolen from their evidence locker. During that investigation, they found the evidence tech that was stealing the drugs and selling it on the street. During that investigation, they also came to aware that this individual was also having, we'll say, inappropriate relations with some of the police officers, some situations on city time, in city facilities. They disciplined those officers. The press want to know, who are these officers? The city's position was, that's not public information, that's an in-house policy. They violated policy. They didn't violate the law, they violated an internal policy. We've disciplined them on that policy. We're done. The press said, no, we want to know who they are because they're lacking good judgment because they're having these inappropriate relationships on time, on public time, in public facilities. So they said, you know what? The city said, we don't want to violate one or the other right. We're going to go to the judge and ask the judge for a summary judgment. And the judge said, you've got to release that information. They've met that threshold, release the information. So before the city said, okay, in 3 days, we'll have a press conference, release the information. And in that interim, they gave the opportunity for those officers involved, implicated in this scandal, to come forward and said, it was me, I screwed up, and I resigned. Or it was me, I screwed up, and I won't do it again, please keep me around. So again, that's how a lot of these cities are now, cities and counties are dealing with it. We don't want to call that shot. We're going to let the court. Why the court? Because they don't have, they have prosecutorial immunity. Because what the court says is what it is. It's either private, public or private. You can't sue the court saying, no, you release it because they're the final arbitrator. The deal's done. The city does it, you can get sued, one way or the other. But the court says, you're done, discussion's over. So now they're saying, I don't want to get in the middle. Go ahead.
You touched on real briefly and reflected on a closed meeting. We're keeping minutes during a closed meeting.
Oh, yes.
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 And what I want to know is, as it is with an individual who may be being discussed, and they say, I'm fine with this coming out into the public, then in that case, are those minutes also made available?
That's a good question.
In that situation.
Yes, if I would, my default guess on that is if someone after the fact says, okay, I waived my right to privacy, but I would have them in writing release those minutes.
Sure.
I would say, oh, they posted about it on Facebook, so now it's public.
So in the event that that doesn't happen and those minutes remain sealed, if you will, they remain sealed until there's until litigation proceeds or something along that nature, and then they become available.
Yeah, let's read what the law says, and you'll know what I know, and then I'll tell you what more things I know. So, anytime, so I'm looking now on the top of page L4 to highlight, it's subsection 4. Anytime the presiding officer closes a public meeting pursuant of 23203, the presiding officer shall ensure the minutes taken in compliance with subsection 2 are kept of the closed portion of the meeting. That was not the case until 2015. That was a new law just added. The minutes of the closed portion of the meeting may not be made available for inspection except pursuant to a court order. Or what I would say is I'd have a policy. If you want that released, you'd have to sign a waiver saying that you are releasing that information. Now, here's how I'd operationalize this. On your meeting, because you have meeting minutes you need to approve, right? Now, how do we approve those? So what I would recommend is you have one set of meeting minutes. That is for the public meeting portion, right? Anything that happened out here, that's all readily available, email, now you do your normal thing with those. The minute taker, whoever's taking the minutes and preparing those minutes, should have a file on their computer that's under password protected, should be kept with you.
Yes.
Yes.
That's what we do.
So it's under secure of the attorney. Writes up those meeting minutes and then place them in a manila envelope, and on that envelope says date, time, place, who was there, what was the topic, right, to discuss personnel issue for bar. Then at the meeting, the commission will approve the general meeting minutes, the open meeting minutes, and then pass around to each of those that were there to then review the meeting minutes of the closed portion. So they take the envelope, look at it, yep, and then I'll initial, I'm good with it, and then I'll entertain the motion. Okay? Now, what I'd also put on the agenda of that meeting is possible executive session to approve minutes. Because there may be something in those minutes that's substantively wrong. And you can't correct it without revealing or disclosing the privacy issue. Now, if it says, oh, this needs to be capitalized, oh, we need a comma there, that stuff, that's fine. You can do that in the open meeting and make those corrections. But if there's something that's like, oh, that's like way off, we need to correct the record, then you can, so I would preempt by saying possible closed session to approve minutes. Then you go on executive session, you fix the minutes, but what's going on in that meeting? Taking more minutes. Then the next meeting you do the same thing. Possible closure. So the deal is that we don't want to be in a perpetual, you can't go into closed session to approve the minutes, because you'll be in a perpetual state of always having a closed portion of the meeting to deal with minutes. So it should be a one and done, or at least a two and done, right? Fix it and be done with it. And then you seal it up, write on there, not to be opened without a court order, you give it to the county attorney, or the city attorney, whatever the case may be. Now, you get a new mayor elected, right? New mayor comes on board and says, ooh, I want to see all those closed meeting minutes. I want to see all the dirt that's going on in this town. And you say, great, love to share them with you. Show me your court order, right? You don't get access to that just because you've been elected. It's none of your dang beeswax, right? So there's that. If you want to have a policy around waiving those rights and here's the thought. Here's another thought. That's why I want you to waive that right. You can't make the judgment, they told their story on Facebook, so now everybody knows, so we can release that information. Here's a little story for you. This is Gravelgate, right? Do you remember Gravelgate? Have you read about that? So this happened, I'm going to tell you the story. It's like a seedy novel. It's nasty. And you can read all about it in AG opinions and Supreme Court case notes. Years back, like in the early 80s, when this was we're all new to this, and we're trying to work out all the kinks. What does it mean when it says this, right? The ambiguous language, we want to clarify. So there was a situation, again, police chief was having inappropriate relations with a citizen on city time, in the city police car, down at the city's gravel pit. See where this is going, right? Somehow word gets out. Oh, you know how the word got out? During their
Tryst.
the liaison, the mic on the became open and everybody could hear. So that's how it got out. Now, we've got a personnel issue on our hands.
10-4.
So now, everybody knows what went on. The city's trying to figure out how do we discipline this individual. They're still trying to figure out who. So it ended up before I think the police chief appealed. We'll say he appealed because there should be no reason why the council's dealing with a personnel issue anyway, unless it's part of the appeal process. You don't manage people, the mayor manages people. That's a whole other discussion here. That's another meeting. So the council's having a meeting and inviting the woman to come in and give her side of the story. The due process. Give us your side of the story because we need to discipline at some point. We have to deal with this personnel action. What's your side of the story? The police chief sued the city saying, no, that doesn't justify a closed executive session because it's common knowledge. Everyone in town already knows what happened. So she has no expectation of privacy because it's common knowledge. Oh, got a smart lawyer. So the courts came back and said, no. Regardless of the public knowledge, the common knowledge in the community, she still has an expectation of privacy. The meeting can be closed. So back to your question. If it becomes common knowledge, should we just release that information? And I would say, not unless you get a release from them, because I think you still have a duty to retain that regardless of what people know. And the other thing is, if you have a closed meeting and with an employee and they say, you know what, I want to bring my attorney. Great. I want to bring my cousin, my nephew, my mother, my wife. Bring the whole dang town, I don't care. But as far as we're concerned, this is a closed meeting, we're not letting it out. It's up to you to decide how you want to manage your personnel or your privacy issue. But as far as we're concerned, we're Fort Knox. Bring whoever you want. We're not saying a word. Does that make sense? So let them, don't get too parochial and try to tell them how to deal with their privacy issue. Let them decide. It saves you all sorts of headaches. You're Switzerland. I have no opinion here. I'm just following along. All right, other questions, thoughts, comments? Did we get everything? Did get?
One more question.
One more question.
Going back to your legal meeting,
Yep.
so if there's there's no minutes, does that make it a legal meeting? No agenda, no meeting, no minutes, is that a legal meeting?
Well, I'll just reiterate, if there is a quorum present and they're hearing, discussing, or acting on something within the jurisdiction, they need to have notice, an agenda, public note, comment, and minutes.
Okay, otherwise it's illegal.
I would just say, if there's a quorum present, all those things have to be in place.
Okay, then it's illegal.
So let me ask a question on that question. What if it is a work session? It's on the agenda, but it's a work session.
So work sessions you'd still, because there's still a quorum, you're still hearing, discussing, or acting something in your jurisdiction. So that all those things would still
No
apply.
decisions are making.
No, well, But it's the or. You're discussing something within the public sphere, within your jurisdiction.
Okay,
So that would
it's
constitute
It's
me.
a budget work session. There's no decision, it's just a bunch of blank pieces of paper, and they're providing us figures through the clerk and recorder's office. We need to take minutes.
How do you take
How do
minutes?
you
So-
take minutes?
So you don't have to take detailed minutes,
Yeah.
you were gonna reflect in the minutes that there
Well,
was
we did
a
that.
meeting to.
Yeah, if there was a meeting, it was a work
So that you've
session.
given.
This is what we did, yeah, okay.
Yeah.
So does it suffice to say, okay, we had a work session between these minutes and hours, this is what we did, done.
Well, so one thing to consider, the budget is probably the most important document of any local government.
Right.
Because that's how we are choosing our priorities of what we're funding. So it's a pretty important discussion. So you just got to decide and work out with legal counsel, how do we, in a work session, it may be informal, right? We're bringing a department head in and let's talk about your budget. But if there's a quorum and you're discussing the budget, yeah, so I think there should be minutes. The level of detail you need to decide because it's the substance of those things heard, discussed, and acted on.
Okay. The budget didn't exist, okay? We were formulating the budget. That's why we had a work session. We did notice it was open to the public. And it's basically a set of discussions between commissioners and adding and subtracting and this doesn't
Yeah.
fit or go get the clerk and recorder, let's see. And,
Yeah.
you know, that's what it was,
It's
okay?
messy sausage making.
Yes, and we did say, yeah, we had a work session between these hours on the budget. That's what we did.
Yeah.
Okay, is that sufficient for minutes? It was in the minutes.
Yeah, based on what you've told me and in the minutes, yeah.
Okay.
So,
Can the public interrupt that session?
within that session, you should have some point public comment.
We did.
So you'd start out with public
But
comment.
Can they interrupt just any
Yeah.
old time? Just
I would say no. I'd say that you might, on occasion, say, what does the public think? Do you have any comment on this particular thing that we're discussing here? And say, thanks for your comment, now we're back. And it's public comment, so I just want to be clear about that. It's public comment. The public has the right to comment, to help shape, to influence. Now, if a person chooses to ask 50 questions during their 3 minutes, that's fine. There's no expectation for the governing body to respond to those questions. Right? It's public comment. It's not public debate, public dialogue, public question and answer. You can if you choose to, but there's not an expectation that you have to respond to that. Does that make sense? Because we get some of those people come in and say, what about this, what about this, what about this? Are you doing da-da-da-da-da? Say, great, thanks for your comment. And it could be one of those ground rules where you say, please make your comments solution-oriented. Just asking a question doesn't help me. It's a complicated issue. Yeah, we get it. We see those same things here. We're trying to find a solution. So you could kind of encourage the public to, yeah, we're flummoxed too. What do you got? Just don't tell us it's a bad idea. Give us an alternative. You had a
This
thought.
goes back to Robert's Rules of Orders, and if you go watch the Parliament in London, or you go watch
It's always
what's going on in
entertaining.
the House,
Yeah.
right? Every statement begins with Mr. Speaker, or in our case, Madam Speaker,
Yep, Madam Chair, or whatever. Yep.
whatever the situation is. And, okay, I'm just
Thinking out loud.
coalescing in my mind, thinking out loud, yes.
So, and that's one of those things, those cultural things. You go to testify before the legislature, and it's very formal. I did that a couple weeks ago. Hated it. Because I'm like, I'm going to tell you up front, committee, I'm not going to follow your rules. Because I can't keep track of them. Right? But every time a legislator would say, Madam Chair, I think it was a madam.
It was always Madam Chair.
And then she would recognize back, Representative so-and-so. He says, can I ask the speaker a question? Go ahead, right? So you're asking permission, so it's like kind of a call and answer. So it's a very formal way. This is how you can really diffuse a very tense situation, the level of formality. Because you're making it not about, I'm not engaging in a debate between me and another council member, right? That everything goes through the chair, and that really keeps the level of civility, right? Because you're talking to the chair, you're addressing the chair, comments are made to the chair. And I'm not making snide, snippy comments to the people sitting next to me, right? So there's a level of formality to that. And so it could be, and that's what we've encouraged councils that have gotten really, just a mess, is you need to up your formality. Because it's just a free-for-all. You just come here and it's a bitch session. And they just yell at each other. And it makes great TV. Because then folks show up and they put it on Facebook Live and they think, oh, this is fantastic. It's great entertainment. Better than Dance with the Stars. Right? For that town, you got better ratings. But yeah, and that's not how you want to be perceived in the public. We've got a couple of communities that are just in a terrible state right now. And I keep saying, is this really the public face that you want to have? There are people out there in this state and around this country and world that want to make an investment. They want to move someplace. And what better place than Montana? And they're thinking, they're always looking, if we relocated to Montana, they got high-speed internet, they got a qualified workforce, they got fantastic amenities. We're going to move out of D.C., we're going to move to Bozeman, Montana, because of fishing, the hunting, the hiking, the bike riding, all the blah, blah. Or here, ski hill, river, open space, not a lot of people. Why not here? They go online and look at your newspaper and they see nothing but, they're like, there's better places I can go, right? That's not a good invitation. We have a couple of communities where they have, the citizens have made IHateGlendive.com. And that's the thing, when you search Glendive, Montana, it comes up there in the top of the search. And it's people just, it's like 12 people spouting off, right? You got nothing positive to say. That's why I say, give us a solution. Just don't complain, give me a solution. What do you want to get? We've got a broken sewer system. What do you want us to do? Because we can't go back to digging a hole in the backyard. That's not acceptable. So we've got to deal with this. How do we deal with it? And if you don't like the path we're going on, give me some other alternative, because I don't know what else to do. Right? And that's how you formulate the discussion. They say, I don't know either, I just don't want this. Well, that's not, thank you for your comments, what you say. Next, because I can't do anything with that. Got it. Lodged one more that doesn't like it. But that doesn't mean we don't move forward. It doesn't mean we're going to stop because you don't like it. Because we still have a duty regardless of what you like. Here's another thing about rights. As I get on my rant here. That's one of the things that we like here. Right? We have certain rights. And just because the majority can influence the legislative branch to pass a law that may infringe upon people's individual rights doesn't mean it's correct or right. Just because the majority wants it doesn't mean it's not inconsistent with the Constitution. So that's where they pass a law that would be inappropriate. The executive branch implements it. Now I feel like I'm harmed. My rights have been taken away. So I can go to the judicial branch and sue them. And that's where they say, look, you can't do that. Voting Rights Act was one of those examples. Just because the majority of your state doesn't want to have a certain class of people vote, and they make laws to disenfranchise them, doesn't make it right. Just because the majority wants it. Because we love to say majority rules, right? No. Majority doesn't rule. There are rights rule. Right? But it has to go through this process to come back for the rights to be then claimed back by the judicial branch to say, yeah, the laws that you had in place were infringing upon these people's rights. And we need to make a new law that's going to ensure that their rights are not being trampled. That's just an example. We had one here a couple times in Montana. We had some lawsuits dealing with the Voting Rights Act, where they had county commissioners that for years had been voted in, where 70% of the population of that county was Native American, and they had historically, 40, 50 years of never having a Native American serving on that commission. Because the way they drove through the districts, split that vote, and they said, yeah, you're playing games, and so they forced that county to change the way they developed their districts so they could have more of a representative government. And it was finally that community said, look, we are not getting the representation that we feel we deserve. At least give us a shake, because the way you design it, we have no chance of getting representation. And the federal government stepped in and said, it ain't happening. You got to fix it. So, majority doesn't always rule. We have rights, that's what rules. But it has to go through this process, right? Because we're doing all sorts of crazy things here all the time.
It's called democracy, and democracy is nothing more than two wolves and a sheep is voting on what they're going to have for dinner.
Yeah.
Well, that's what they call it, that's a democracy.
Yeah, it's messy, but I don't know if I want to live under any other system. Right?
It's a republic.
Yeah. And it's a representative democracy, right? A representative, or it's a republic.
Representative Republic.
And so we have representation. That's where we all can. So we do have one town in this state that has a town hall meeting style of government. 10% of the electorate represents the quorum. And they come together annually and they have a meeting, they pass a budget, They pass resolutions, they pass ordinances. They do that a lot in the New England. But by and large, most of our communities are, we elect representatives, then we try to influence them, we try to use good judgment, we don't make good decisions, we boot them out. All right, we didn't get to everything here. I did want to talk really briefly about this whole serving on different boards. I'll have concern if you're serving on 2 boards, if they're elected boards. Being if I'm a county commissioner, I can't run for school board, right? Incompatible offices. County commissioners, however, based on their resolution creating, say, a board, an elected board, like a refuse district, may have a seat on that board, and all the rest of the board members are elected, but a county commission might have a seat on that board. It's a permanent seat, or a commission is a permanent seat. It's how you develop and draft those resolutions creating that board. Not a conflict of interest, but they're representing the interests of the county on that board.
So the question came up, is there's a member elected to the, or appointed to hospital district?
No, she was elected to hospital.
Elected,
The hospital district is elected
Yeah.
position.
appointed to the school district to fill a vacancy. I gave a legal opinion under MCA 1310-201, you can't do that. And it talks about filing, but
Yeah.
my opinion was you couldn't do that. School district
It's common law, the common law on incompatible office is what they use.
School district attorney said, no, that's fine, you can do it. So right now, they're currently doing it, but I was potentially going to ask for an AG's opinion on it, or letter of advice.
There's a couple AG opinions that deal with incompatible office.
So
I can try to send those to you.
So I tried looking those up, didn't find
Yeah.
it. I looked at the case law.
There's a couple of them, AG opinions deal with incompatible office. There's another one of these crisis that we happened in, by Billings, Laurel. They had a public works employee was elected as the mayor. We said, fine, but you got to choose one or the other. You can't do both.
Yeah.
Well, I want to do both. I don't care what you want to do.
So, yeah,
You can't do both.
I've seen that one.
'Cause
Because there was one
that's
about, even with the hospital district, I
Yeah.
think there was one. But, yeah.
School, so some of it, so that there might be some squishy. That's where it's
Yeah.
good to get on this case, it would be good to get some advice from the AG. Because they could say, is there an overlap within duties of, I can see a county commissioner and a school board being in conflict because funding and there's some decisions there that they may potentially have influence over. But if there's a far enough, there's not a lot of overlap in jurisdictional deliberation between the two bodies, maybe, but then who's going to determine that? So yeah, both being elected offices, I can also say, yeah, you're conflicted out because you're 2 elected offices. Although you were appointed, you're still occupying an elected seat.
I agree with your.
But they don't pay anything either way, so there's no conflict there.
Yeah, there's no conflict there to pay, but that's, yeah, it's mostly about the overlap of.
I think the appointment, quote unquote, is a good distinction to make, because in our particular instance here, I went through 3 years on a town council where there was no one elected.
Yeah.
So there's a distinction to be made there.
Yeah.
Well, 1310-201 talks about filing, but
Yeah.
that's
Still being appointed for an elected office, and that's where I'd say that it's the office, not necessarily the method in which they occupy the office. My non-legal opinion.
I agree with you.
I'm not an attorney, but I do stay at Holiday Inn Express a lot. That's where I got my law degree from the breakfast there.
Well, thank you for coming.
Yeah.
Are you done, or do you need to?
No, heck, you guys look like you're ready to soldier, like you sit on the edge of your seat all the time. Thanks for being here, appreciate